a lot of ways what the union can do in the workplace, you should be able to do as someone who, if you oppose the union, to speak against the union and tell your coworkers, that you may have differing views of the union.
I just felt that if nobody else is going to step up, then somebody has to, and everybody can look around and say, oh, the next guy will do it. But then that person says, oh, the next guy will do it, and so on. And somebody has to stand up, put your feet on the ground, and you have to say, that person is me. And believe me, I did have a lot of support. I had many, many organizations like Freedom Foundation, Bill, who is my attorney at National Right to Work, Fairness Center, AFFT, you name it, all the groups out there to help and give me support. And many of you, when you learned about it, sent me thank you cards, which I still have. I've got them in a kind of a scrapbook at home, and I do appreciate that. But you just have to step up, and you just have to say it can't be somebody else, it's got to be me.
Thanks, Mark. Next up, we have Bill Messenger. Bill is the Vice President and Legal Director at National Right to Work, and obviously, more importantly to this conversation, Bill was one of Mark's attorneys on that Janus case. And National Right to Work is another group that the Freedom Foundation works with. They have a great group of attorneys. They exist to sue unions. They're good allies for us in this fight. So, Bill, I think we should start here. You're an attorney. I want your legal perspective on things. But how did we get to Mark's decision? What's the history here that brought us to where we are today?
Sure. So where it started is in the late '60s, they started to move compulsory union fees from private sector employees to government employees, public school teachers, the rest. That was a new phenomenon. It didn't really exist before the late 1960s. But then it started to spread as a variety of states started to force their public servants to pay money to a union to keep their jobs. That raises serious First Amendment issues. And so the Right to Work Foundation brought a case. It's called Abood versus Detroit Board of Education. Mark referenced it earlier. This is a case from the 1970s. And unfortunately in that case, the United States Supreme Court said it basically was constitutional for the government to force, in this case was public school teachers, to pay money to a union in order to keep their jobs. So we have this problem of, we have compulsory unionism spreading through the states, and we have a Supreme Court decision that says it's constitutional to do this. So that sort of began a very long litigation battle of trying to overturn Abood and strike down compulsory union fees as unconstitutional under the First Amendment. Battle didn't go anywhere for a while. That was sort of like ramming your head into a brick wall. But eventually the wall started to break around 2012 with a Supreme Court decision called Knox, where the Supreme Court suggested that maybe Abood was wrongly decided. Then after that came Harris, which Mark mentioned earlier, which also came out of Illinois, in which the Supreme Court basically said, we will overrule Abood in the right case if and when it comes to us, but Harris wasn't that case because Harris didn't concern public employees. And then we just needed the next case to get up there to fight forward, and Mark's case was ultimately the one that reached the court and the one in which the court held that compulsory union fees do violate the First Amendment. As a result of Mark's decision, freed about 5.5 million public sector employees, mostly school teachers, from having to be forced to pay money to a union to keep their jobs.
Bill, perhaps you can also tell us, we've got a room full of teachers again, perhaps you could tell us what do these teachers have the right to do in their classrooms versus what do they have the right not to do when it comes to talking about union membership or anything in that regard?
So I'd say the line to be drawn is when you're on work time and in a work location, the school district can restrict you about not speaking against the union. You're supposed to be, teaching. And so if the school district wanted to say while you're, acting as a teacher, don't get into that area, that's permissible. However, in non-work areas on your own time, you are completely free to say anything you want about a union, free to campaign against it, free to advocate against it, every bit as much as the union does, because obviously the union does it as well. So basically, a lot of ways what the union can do in the workplace, you should be able to do as someone who, if you oppose the union, to speak against the union and tell your coworkers, that you may have differing views of the union.